I don't talk to my family anymore. They shunned me out of their life. I just it's just me and my boyfriend now.
A sensitive situation arose, and instead of handling it correctly, I was intoxicated and I became emotional, and I handled the situation in a disorderly fashion.
I just I don't know that 2 days in jail is going to do what I need to do. I need to be available for my mother.
I realize that there's so much more to life, and I will refrain from any risky behavior because of this circumstance.
She is one of 5 children. This particular instance was done because she was trying to make sure that her family was fed.
Next matter is the state of Michigan versus Colleen Kavanaugh, file 19-36971-SD. I do see Ms. Kavanaugh is with us.
Yes, Your Honor.
All right. This is a probation violation. It reads as follows. It's a technical violation. It says that you tested positive for alcohol on 8/8 of 25, and you missed calling the testing line on 8/15 and didn't test as required. There was a previous probation violation on 8/5 of 25. You admitted to consuming alcohol, resulting in a positive test on July 30th. And you were to complete one work camp day, which is scheduled for 9/9. And the recommendation as a result of these violations is that you serve 2 days in jail. Do you have an attorney that you want to represent you, or do you want to represent yourself?
I can represent myself in this.
All right. Do you understand the nature of the allegations made against you?
Yes, Your Honor, I do.
You understand the recommended penalty of serving 2 days in jail?
Yes, Your Honor, I do.
All right. You have certain rights. If you wish to have a hearing, you could have a hearing by pleading not guilty and contesting it. At that hearing, you'd have the right to see, hear, and question the witnesses against you. You'd have the right to present witnesses and evidence on your own behalf and get an order from the court requiring those witnesses to appear and testify. You could testify, or you could remain silent, and that silence could not be used against you. You'd have the right to be presumed innocent until proven guilty by a preponderance of the evidence. That's 51%. And that burden of proof would remain with the probation department at all times. Finally, you'd have the right to automatically appeal. However, if you enter a plea of guilty or admitting what you did, you would give up all of those rights. Do you understand that?
Yes, sir.
All right. How do you wish to proceed today? Do you want to admit or deny and have a hearing?
Actually, I don't really know. My attorney was not notified until just Tuesday, and I didn't know if I could get an adjournment so I could speak to her about this, or
If
is
you
that?
wish to have an attorney, we'll make whatever needs to happen. So you told me you wanted to represent yourself, so if you want to change your mind and have an attorney, that's fine. Just let me know that.
Uh, well, gosh. Okay. No, it needs to be taken care of. This is from 7 years ago. We just need to get it done. So I will just represent myself. We'll just go forward today with what we're doing.
All right. I'm certainly happy to give you whatever time that you need to discuss things with an attorney, but you also have the right to proceed on your own. So if you change your mind and want to proceed with an attorney, let me know. Otherwise, we'll proceed as we are now. Now that you're representing yourself, do you wish to admit, or do you want to have a contested hearing on this?
I do admit that I missed a call. I've been going back and forth to Royal Oak with my mother being sick, and honestly, I was supposed to be to work that morning at 6, and I didn't go into work until 2 o'clock in the afternoon because I just slept. So it was not an intentional call. I have tested out of the area because I was out of the area with my mother, and have tested negative for everything. I know that I've had positive tests before, and they've been because my allergies are so horrible. So I'm not really sure what that other positive test was. I know from the wedding, I know what that was. Ignorance, and this could have all been done had I not been doing that. It's just been a lot with going back and forth with my mother and not being able to work and not being able to take care of this properly because I'm just exhausted.
So the allegations are two. First is that you tested positive for alcohol on August the 8th of 2025. Is that true?
I do not believe that to be true. The only time I drank was at the wedding.
I don't know when the wedding was.
Oh, I'm sorry. That was, let me look. I don't recall the date. It was the end of July. When was it? Haley's wedding. July 26th, and I believe I tested positive the week following that.
July 26th was a Saturday.
That is correct.
The week following that would have been through Saturday, August the 2nd. This says that you tested positive on August the 8th. Ms. Hill, how was that test done and what were the results of it?
The positive test from the wedding she's talking about is her positive test from the 30th, her first violation. The 8th was almost a week later. She tested positive again at Great Lakes screening. And I believe I have that test result in the file for you. It was loose. It wasn't.
All right, well, she's not admitting to it yet. The second allegation, Ms. Kavanaugh, is that you missed calling the testing line on August 15th and didn't test as required. Is that true?
That is 100% true. Yes, sir. I have missed calling before and gone in and gotten tested. Like I said, when my number was called, I was tested in Sterling Heights. I have too much going on right now with my mom that drinking is not on my priority list. And missing work. I also miss out on money, so it's not like I would even go buy any beer right now if I wanted to because I don't have any money. And I can get you information about my mother's, I can get you doctor stuff. She's got an aneurysm on her cerebellum. She also has cancer in her bone marrow, so she bleeds really easily. So there's really no way to go in and fix that without her dying on the table. And at 86, she's not really willing to take that chance. So, yeah, I did miss that call. I was in contact with Miss Hill, letting her know where I was because I, in the middle of the night, left and was down there for, I think I came home Thursday at like 1 o'clock in the morning and I was just exhausted and I truthfully just slept through. And then by the time I woke up, there wasn't a testing place open that I could have gone to, or I would have.
All right, Ms. Hill, I do not see, and it's probably me missing it, but I do not see any documentation of the positive test for August 8th. That would make an impact on my decision about what to do in this particular case. It appears that she's not willing to admit that now. So I'm going to set this for.
I just printed it. Do you want me to bring it in real quick?
That'd be awesome.
Okay, I'm bringing it in real quick.
Thank you. Of course, now that she's done that, I find it.
The first page is the original. The top page is the results from the lab.
Thank you very much. All right, Ms. Kavanaugh, I've been handed a document indicating that a sample was collected from you on August the 8th at 9:48 a.m. was sent to the lab, confirmed positive for alcohol, both ethyl glucuronide and ethyl sulfate above the limits. It's confirmed positive. The amounts were 400, it probably won't mean anything to you, but the amounts were 432 nanograms per milliliter of one type of ethyl alcohol and 321 nanograms per milliliter of the other type of alcohol that they test for. Both of those are much above the cutoffs, which are 100 nanograms and 25 nanograms. So well within the positive range for alcohol. You have the right to have a contested hearing on this, at which the probation department would explain to me how this was obtained and how the results came back and what the results were. So do you want to admit to that, or do you want to have a contested hearing on that?
I really don't wish to drag this out any further. I mean, I know what I did and I know what I didn't do, but I don't even know what those words mean.
Basically, it's telling you that they test at a level of 125. They give you that much of a break. If it's less than 100 or less than 25, whatever that nanograms per milliliter means, that amount, they give you the benefit of the doubt for. They say it doesn't make a positive test. Your tests were at 432 and 321 for the two types of alcohol that they test for. So much, 4 times higher than one test, and what we got, 12 times higher on the other one. A lot. Okay, so you have the right, if you think that you didn't drink, you have the right to contest these. The probation department would have to prove to me how these tests were taken and how the results were obtained. So all these are right now are allegations. It doesn't mean that they're true. If you don't want to admit that, then don't admit it. We'll have a contested hearing. We'll see if the probation department can prove their claim. All I'm saying is, I think this is an important enough issue that I want to know about this one way or the other. So it's up to you. Do you want to admit to it, or do you want to have a contested hearing and have the probation department prove it?
I just do not wish to drag this out any further, so I will admit to it.
All right. Did you in fact consume alcohol and test positive for alcohol on August the 8th of 2025?
Yes.
All right. You understand that by admitting that I'm going to take that as a serious violation,
Yes, sir.
that there may be consequences for that. You
As
understand
well there
that?
should be.
All right. Knowing all that, do you still wish to enter your guilty plea to consuming alcohol on August the 8th?
Yes, sir.
All right. Court will accept your plea as to both the issues of having a positive test on August the 8th and missing the testing line on August the 15th. Let me catch up on my paperwork here.
Easy.
All right. You have the right to tell me anything that you would like to tell me by way of explanation. I believe you've done a lot of that already, but if there's anything else that you want to tell me before I impose sentence, now would be the time for you to do that.
I don't really have anything to say. I mean, I've reported, I've done everything, I've paid all my fines. The only reason anything has gone sideways is because of that one text I got from my uncle about my mom being taken to the hospital by ambulance in the middle of the night. So that's kind of got me all whatever. But I go to work every day. I am driving back and forth to Royal Oak. I've taken care of all the things that I am supposed to take care of. Maisie, I'm very sorry about my dog. Sorry, she's being loud.
Right.
I don't know that 2 days in jail is going to do what I need to do. I need to be available for my mother. Because she's really scared and we're all really scared because, aneurysms aren't a thing that end up well. So, with that being said, you do as you see fit. I just want to get this taken care of. Like I said, this is from 7 years ago. I need to focus on my family and what is going on around me with work and my mother. So I would like to do whatever I need to do to get this done.
Ma'am, I can certainly understand the difficult circumstance that you're in. I'm 63 years old. I have parents that are failing and have failed. I've gone through that set of circumstances, so I certainly understand and sympathize with where you're at. My concern is how you're trying to hold up under it. And this now is the second time that you've turned to alcohol to deal with those stressors. And you say this is a 7-year-old case, and you're right, the underlying violation that brought you before the court was 7 years ago, but it appears that you're still using the same coping mechanism. And that is you get to the point where you feel overwhelmed, and so you want to numb that feeling and you turn to alcohol. And what that's going to do is it's going to bite you in the end. It's a quick, I don't even want to say a fix. It's a Band-Aid. And all it really does is cause the underlying problem to fester. It creates a boil, and it is worse than the problem that you're dealing with.
100%.
If you're going to have issues, and you certainly have a reason to have issues. I'm not saying that there's anything wrong with feeling the way that you're feeling, but how you're dealing with it, especially while you're on probation, it can't be done anymore. I don't have a particular need to put you in jail. When we dealt with the first issue, which was relatively short period of time ago, we said do some work camp. And quite frankly, if you'd had time to do that, I think it's scheduled not for till the 9th, right? When you were supposed to do that.
That is correct.
So it hasn't been completed yet, and maybe that would have had an impact on you, and maybe it would have stopped you from having this, I'm going to call it a relapse. So what I'm going to do is I'm going to actually give you the benefit of the doubt. I'm going to say you didn't have a chance to have a penalty and think about what happened after the first violation at the end of last month. But this has to be a clear wake-up call to you. So I'm going to give you 2 days at work camp instead of 2 days in jail.
Thank you.
But I have to tell you, you've been warned. Now you've got to change what you're doing. And if that means that you need to go to a therapist, if that means you need to talk to a counselor, if that means you need to get some additional education, whatever you need to do. And I would hope that you would do that, because you're going through a very stressful set of circumstances. And this is a difficult time for anybody. So I'm not saying that you're failing in any way, other than you're not taking care of yourself appropriately, and that's leading you to make bad decisions. So I'm going to give you a chance to rethink that. But this is your last time that I'm going to give you the opportunity to educate yourself and to rethink. After this, it tells me that you're simply deciding not to do those things, and punishment will be necessary. So I'm giving you a chance to make new choices, deal with this in a different way, talk to your friends, talk to a counselor, go to church, whatever it takes to help your soul, because I think that's where you're hurting. Your soul is damaged at the moment, and rightfully so under the circumstances that you're in. But you can't keep making bad choices as a result of that. You understand what I'm saying?
Yes, Your Honor.
All right.
I haven't drank in probably almost a month since the wedding, or well, whatever, the 8th.
Yep. Going forward needs to be period. End of story, right?
Well, I need to be
at that
available
age
for my mom, and I can't drive to
Exactly.
Royal Oak if I've been drinking, because that'd be dumb.
Exactly. You got bigger things to be worrying about than alcohol. So
Absolutely.
2 days work camp to be done within the next 30 days. So that gives you some time to get your schedule together. I know you've got the one scheduled for September the 9th. This would be 2 days in addition to that within the next
Yes, sir.
30 days. So basically you got 3 in 30 days. You should be able to accomplish that. You have any questions about anything?
No, Your Honor, I appreciate your time.
Please make some good decisions so we don't have to have this conversation again.
We shall not.
All right. Best of luck to you.
Thank you, sir.
All right, I do see Ms. Hubert with us. Counsel, Mr. Pomeranke, this is your case as well?
Yes, good morning, Your Honor. Devin Pomeranke on behalf of Ms. Hubert.
I believe we were here back at the end of July, no, excuse me, early August. And a plea was entered. Has there been a substance abuse assessment obtained yet?
There hasn't. My email indicates that a copy was forwarded to the 87th District Court as well.
I do not see that in the file. Let me look again.
I don't have any record of receiving one.
Who did you send that to, Mr. Pomeranke?
I believe that Catholic Human Services sent it. I saw y'all CC'd in the email.
I'm getting a big nod no from my staff indicating that they did not receive it. I do not see it within the court file. It would be unusual for Catholic Human Services to send it to us.
Oh, there was a release, and I can
If you can send it to us now, we may be able to proceed today.
yeah. Where would you like me to send it?
Want to give me your email?
Yep.
Or- Listen, and my staff will let you know where to send it to.
My email address is B as in boy, HORRIGAN at Otsego County MI.gov.
Can you read that first part one more time?
Yep. B as in boy, HORRIGAN.
Send it right now.
All right, I've received a substance abuse. Well, we've already called the case. So I received a substance abuse assessment report from Catholic Human Services, and looks like the person involved was Nicole Stein Fisher, who appears to have the appropriate credentials for doing a substance abuse assessment. And the indication is that Ms. Hubert does not have a substance abuse problem, does not meet the criteria for diagnosis, and the recommendation is that she take an alcohol highway safety education class called Prime for Life. All right.
Your Honor, I can inform the court Ms. Hubert has reached out to get into that next Prime for Life course when it's available. She's waiting for a call back.
Thank you. I appreciate that. All right, Mr. Fortier, for the prosecution, any allocution?
Your Honor, just recognizing that the substance abuse evaluation does indicate that she doesn't have substance use disorder. I would note that the breath test in this case, there was actually 3 of them done, 0.188, 0.177, and a 0.182. So just close to the threshold of that high BAC number. I hope Ms. Hubert realizes how dangerous it is to drink and drive. She doesn't have any criminal history, so this is a first ever offense for her. So I just hope that things click and she doesn't find her way back in here. Recognizing that the evaluation doesn't indicate that she has an issue that needs to be addressed. and that she's already signed up for the Pride for Life class. I would also ask that the victim impact panel be ordered. And then I would leave the issue of whether or not any probationary oversight is necessary to the court. In addition to that, there is a $200 reimbursement request to the Michigan State Police.
All right, Mr. Pomeranke, elocution.
Yes, Your Honor. The reimbursement fines and costs won't be an issue. We can take care of those. Your Honor, I know Ms. Hubert from prior to this, and we talked, since this has happened, about what the most important aspects of her life are. And, first and foremost, she's a mother. And I know that is something that she wears as a badge of honor and means the whole world to her. And I know she's reflected a lot on this decision, these circumstances, and what kind of position that puts her in. I also know that she loves her job, and this kind of instance, while not job threatening at this point in time, is certainly something that will resonate, as well as it could be a potential consequence if this behavior ever reavails itself. I do not believe that Ms. Hubert has any issues outstanding with alcohol. There's no addiction here. This was something that was done in a social scene, and just went too far. I think she's got the right controls in her life to make sure it doesn't happen again, and I think she might even elevate those controls with some of the tools she might learn with Prime to Life and any other programming that the court may require. She has no criminal history. I would be very surprised if we ever see her again, Your Honor. So with that, I know she wants to address the court a bit herself, but so I would yield to that.
Thank you, Mr. Pomeranke. Ms. Hubert, you also have the right to address the court. I'm happy to listen to anything that you'd like me to know.
I just wanted to start with saying that I'm so very sorry, and I'm extremely thankful that I did not hurt anyone or myself in the process. I have reflected on the decision that I made that evening, and I realize that there's so much more to life, and I will refrain from any risky behavior because of this circumstance. My daughter and my job are two of the most important things in my life, and I just wanted to apologize again, and thank you for your time.
Thank you, Ms. Hubert. It does appear to me that everything that I've heard is positive. You appear to be a very responsible member of our community. You have a young daughter at home that you're raising, which is great. You appear to have good family relationships, so that tells me that you've been doing well in the community for a long time. You're an HR director at a company, so I know that you have a position of authority and responsibility, and are aware of concerns that the court may have. So I am hearing what is being said, but I want you also to hear what my concern is. And that's the issue that was raised by the prosecutor, that at a 0.17, that's an awful lot of alcohol to be able to be functioning at, if alcohol had not previously been a very large portion of your celebration time. You typically can't get to that blood alcohol level if you're just a very occasional drinker. Mm-hmm. And sometimes rather large people can have an awful lot of alcohol in their system and still function well. You do not appear to be a rather large person in my estimation. So it tells me that you have consumed alcohol often enough and in sufficient amounts enough for your body to build up a bit of a tolerance. And that's not a good thing. Mm-hmm. So what you're telling me is that you now realize that you had an issue, and that you're not going to take risky behaviors in the future. It may need to be that you simply say, I can celebrate, I can enjoy my family, my friends, circumstances, parties, whatever, without alcohol.
Absolutely.
Because it's hard for us to know how alcohol is going to impact us. Some people it doesn't affect as much as others, and you may be one of those others without realizing it. So you've got too much good going on to throw it all away for a momentary enjoyment. Okay, so
Completely
enough preaching
understand.
from me. Enough preaching from me. I think that you understand where I'm going with this. I share your attorney's view that you're probably not going to be back in front of me, but I'd really like it to have certainty as opposed to just be a probability. And only you can do that. So enough said. I am going to put you on probation for a short period of time just to be able to say that someone is watching you, because I think that's helpful sometimes to know that we are monitoring, and I have to be on my best behavior. And then that tends to become a habit over time. And that's really what I want to develop, is that habit of self-censoring and making those decisions for yourself. So I am going to put you on probation for 180 days. Typically, if you complete all of the requirements of probation, after you've completed half of the time of the probation, you can get off of probation a little bit early, and I'll let you discuss that with the probation department.
Okay. Thank you very much. I do understand exactly what you're saying.
All right, thank you. There is a cost for that. It's $180. If you get off early, some of that would be come back to you, so it may not be that total amount. Okay. There is a standard or a required crime victim fee of $75. I am going to impose the $200 cost of prosecution request for the state police. There's a $50 justice assessment. I'm going to keep the court costs down. That's $200, fine of $100, and a local charge of $15. Let me add that up for you. It's a total of $820. You can pay that over probation.
Would it be okay if I paid that right now? Or I can call afterwards, whatever.
Yep, I'll give you a number, and you can make that call to the court and set up that payment, and that would be great. Okay. If you wish, you may perform some community service in lieu of some of those fines and costs at the discretion of the probation department. I am going to ask you to enroll and successfully complete in the Prime for Life program, and also the Victim Impact Panel. The Victim Impact Panel is educational. It's information about people that have gone through a very bad experience with alcohol, and they give you some information to think about. And I think it would be helpful to you to know about that. It may also help you understand how alcohol affects you and your body, so that you're able to make better decisions in the future about those things. While you're on probation, there's no consumption of or possession of alcohol or drugs, no entrance into a business where alcohol is served by the glass. That means you can't go into a bar, even if it happens to serve food. Okay. You may go into a restaurant that happens to serve alcohol, but you may not go into the bar portion of that restaurant, and you may not have or order alcohol while you're on probation. Do you understand that?
Understand completely. All
right. There is drug testing at the discretion of probation. That means they could do it today and tomorrow and the next day if they want, or they could do it randomly, or they could do it never. It's all entirely up to them. Just so that you know that we are watching and could test you at any time if we wish to.
Sounds good.
What town do you live in, ma'am?
I'm in Gaylord.
All right. I assume that you work on a Monday through Friday basis?
I do, yes.
What I like to do is have people do a small amount of community service work to give something back to the community for what they've taken from the community for this. I think it benefits you in two ways. One is that you pay a price, and I think that's important to know that you did something wrong and now you're making up for it. The second part of that is the making up for it is you benefit other people, and by benefiting other people, I think it helps you feel good about yourself again too. I want you to be a prominent and productive member of this society, and giving back to the community is one way of doing that, of expanding your reach and being some sunshine in somebody else's life. So you can talk to the probation department. Typically, we use nonprofits or public agencies, the animal shelter, the food bank, any of those kinds of things. And most of those have something that you could do on a Saturday, so you wouldn't have to take off work, although you're certainly could do that if you wish. So I'm going to say 8 hours of community service work.
Okay.
And I'd like you to do that within the next 30 days.
Okay.
So it's something that gets done while it's still fresh in your mind. Any questions that you have about anything, ma'am?
No, I think you answered everything. If I could just get that number from you to pay those fines. Okay, perfect. Thank you very much.
Mr. Pomeranke, anything else from you?
No, Your Honor. Thank
All
you.
right. The number to call, ma'am, for the court payment is 989-731-0201.
Okay, perfect. Thank you very much.
You're very welcome. That'll be the order of the court. Thank you.
Thank you, Your Honor. Good day.
You too. Next case is the state of Michigan versus Olivia Pearl, file 25-43609-SM.
Hello.
Good afternoon or good morning. Thank you for being here. Thank you for your patience.
Mhm.
I believe that this is a review after a delay of sentence, if I'm remembering things correctly.
Yes.
Ms. Hill, do we have any, or Mr. Fortier, do we have any indication that there was any problems with her probationary time?
I don't have anything.
No, Your Honor.
All right. I believe she was given a delay of sentence on a retail fraud third. Ms. Pearl.
Judge, I guess the only question actually at this point would be, I did reach out to Mr. Horgan yesterday, just to make sure that this was something that had to be done through our office and not through the court. There's the $194 in restitution that was supposed to be paid to Walmart. I just don't have verification that that was done. That's the only thing.
All right. Ms. Pearl, can you address that? Have you paid the $194 to Walmart?
Yes, I did.
Who did you pay that to?
I called the courthouse or the clerk. I'm not sure. I called the courthouse.
All her
Yeah,
fines and costs were paid, and I believe the victim was in there.
All right. Do you have a receipt for that? Or Ms. Hill, do you have some verification that there was, I believe that the underlying sentence was $290 in fines and costs plus $194 in restitution. Do you have
And I don't
those
believe the
down?
restitution was paid because the $290 is all that is paid.
Oh my gosh, I am so sorry. I didn't, I guess I didn't understand that or see that.
Okay. How long do you
Is
think it
there
will take
any
you
way
to
I
make
could
that?
pay that today?
All
Yeah.
right. If you do that today upon verification, I can, or Mr. Fortier, is there something else you wanted me to say?
Yeah, so what she can do, Judge, is she'll have to pay that through our office. So she'll have to come up to the building, come up to the third floor to our front desk and pay the restitution that way.
All right. And then what will happen? Will you do the nollie at that point, Mr. Fortier?
Yes.
Or all right. So Ms. Pearl, what he's saying is if you make that payment today, he will file the paperwork to dismiss the case so that you don't have that on your record anymore at that time.
Okay.
And that would be the end of the case. So if you could do that today, that would be appreciated. All right.
Yes, of course. I'm just so sorry. I thought I
No.
paid. I called and they said everything was paid, and that's all that I was told. So I'm so sorry.
No, apology accepted. As long as you take quick corrective action today, everything will be fine. So thank you very much.
Yeah, and
Yep.
and how much was it again? I'm sorry.
194.
194. And where do I go? I'm sorry, to pay this? Because you
It's
said I
the-
had to go.
Yep, 800 Livingston Boulevard. Do you know where the high school is located?
Oh, yes. Is it
So if you-
where CMH kind of is? Community
Yes.
Mental Health?
Community mental health is on the second floor. The prosecutor's office is up on the third floor.
Okay.
You just before you get to the high school, there's an exit towards the court. You go around to the back of the building. You come in the center of the building. There's two wings. Come in the middle of that. Walk around. Basically, it's a big, long right-hand turn or circle, and you'll find a bank of elevators. You go up to the third floor, and the prosecutor's office is the only thing on the third floor.
Okay. Perfect.
All right.
Thank you so much.
You're welcome. Have a good day.
Thank you, Your Honor. You too.
State of Michigan versus Holly Campbell, file 22-41153-SM, set for a status conference today.
James
We
Dick
have
on
Ms.
behalf of Ms. Campbell. She is here via Zoom, Your Honor.
I do see her. Mr. Dick, do we have a resolution of this matter?
Yes, Your Honor. Ms. Campbell will be pleading guilty to the original charge and has agreed to pay the restitution. And this was with no objection to HIDA from the prosecution, Your Honor.
Mr. Fortier, is that accurate?
That is accurate, Your Honor, and the restitution amount is $281.94.
All right, Ms. Campbell, you've heard what the lawyers have said. Is that what you want to do?
Yes, Your Honor.
The agreement then would be that you would plead as charged to retail fraud in the second degree, which is a misdemeanor offense. It has a maximum penalty of 1 year and or a $2,000 fine or 3 times the price of the property stolen. And you would get what is called the Holmes Youthful Trainee Act. That is basically a program that says if you successfully complete your probation, the case is dismissed and it does not continue to be on your criminal record. If you violate your probation, that is, you don't do what the judge says to do, then you would have a criminal record in the future. Do you understand all of that?
Yes, Your Honor.
In addition, you would have to make restitution of $281.94 as a part of that Holmes Youthful Trainee Act or HIDA program. Do you understand that?
Yes, Your Honor.
All right. If you wish to take advantage of that offer, you would be giving up your right to have a trial. So let me tell you what all those trial rights would be so that you can make an informed decision. At a trial, you'd have the right to have a trial by a judge, by a jury. Mr. Dick could continue to represent you as your attorney. You'd have the right to see, hear, and question all the witnesses against you. You'd have the right to present your own witnesses and evidence and get an order from the court called a subpoena to require those witnesses to appear and testify. You also could testify or you could remain silent. And if you chose to remain silent, that silence could not be used against you. At trial, you'd also be presumed innocent until proven guilty beyond a reasonable doubt. And that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error at that trial. However, if you enter a plea, you'd be limited to asking for permission to appeal, and that might not be given. Do you understand all of those rights?
Yes, Your Honor.
Do you have any questions about any of those rights?
No, Your Honor.
Knowing all of that, do you still wish to enter your plea today?
Yes, Your Honor.
All right, I'm going to ask you to raise your hand so I can swear you in. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
All right, you can put your hand down, please. Has anybody promised you anything other than this plea agreement to get you to plead today?
No.
Has anybody threatened you in any way to get you to plead today?
No.
Are you doing this of your own free choice and free will?
Yes.
All right, the complaint against you reads as follows. It says in honor about August the 5th of 2022 in Otsego County that you did commit the offense of retail fraud second degree in that while you were at Walmart, which was open to the public, you did steal property of the store that was offered for sale at a price of $200 or more, but less than $1,000. Is that true?
Yes.
And you were at the Walmart store here in Gaylord?
Yes.
What did you steal at that time?
I stole food.
And that had a dollar value over 200, but less than $1,000?
Yes.
And the food that you stole, that was while the Walmart store was open to the public
Yes.
And the food that you stole, that was offered for sale by Walmart?
Yes.
All right. Do either of the lawyers have any additional factual basis questions?
No, Your Honor.
None, Your Honor. Thank you.
Do either lawyer have any other promises, threats, or inducements that were not stated on the record?
No, Your Honor.
No, Your Honor.
Do both counsel believe that I've complied with the court rule?
You have, Your Honor.
Yes.
All right. I do believe that Ms. Campbell has given me a proper factual basis. She's admitted to stealing food from Walmart of a value of more than $200 but less than $1,000 while Walmart was open to the public and the food was offered for sale. That constitutes the crime of retail fraud in second degree as it happened here in Otsego County. She's also told me that facts which indicate to me that the plea was given freely, voluntarily, and intelligently. So I will accept that plea. Mr. Fortier, do we need to adjourn for a statement from the victim, or can we proceed today?
Your Honor, we can proceed today.
Mr. Dick, any problems with that?
No, Your Honor. We would request that the court does so.
All right. Ms. Campbell, I'm going to ask each of the lawyers to tell me their thoughts as to what a proper sentence should be. And then I'm also going to give you at the end an opportunity to do the same so that you can hear what they say before you have to make any statement to me. So Mr. Fortier, your thoughts on proper sentence?
Your Honor, given the fact that we have no objection to HIDA, I do believe that a probationary term would be appropriate just to ensure that, you know, she's not making any more mistakes, and then giving her an opportunity to pay off that the fines and costs and then also the restitution amount. I did receive certification from Mr. Dick that Ms. Campbell has already participated and completed the economic crimes class, which I was going to recommend that the court order, but since she's already done that, I think the court should still order it, but then she's already satisfactorily completed it. So other than that, I think that the goals would be accomplished with the probation. She has no history, so hopefully this was a learning opportunity for her, and we don't see her back here.
All right. Mr. Dick, allocution?
Yes, Your Honor. So Ms. Campbell, she's currently 22 years old. This offense occurred when she was 18, 19 time period. She is one of 5 children. This particular instance was done because she was trying to make sure that her family was fed. Her parents were not really around, and she didn't have a means to take care of her younger siblings, her elderly grandparents who had been living with the family, and her mentally handicapped uncle who was also residing with them. She essentially was taking on the responsibility to care for her family and to make sure that everybody was fed. Once she got a driver's license, she got a job and started trying to make ends meet. She did what she did, as I said, just to make sure her family was fed. She did initially lie to the police officers about the incident, but she did later admit to it because she was scared and nervous. She's very remorseful for this incident. She has never been in trouble before. She was not aware that there were other avenues to be able to seek help, like food assistance from places such as the E-Free Church, or perhaps assistance through like Red Cross, Salvation Army, whatever else the agency may be. She is aware of that now, and she does work full-time. Pardon me, let me back up. She did come from a bit of a sheltered life, being raised by a couple, let's say rather devout Mormon parents, and she didn't get out a lot. So that is part of why she did not know about any avenues of seeking additional assistance to make sure her family was taken care of. She does work 2 jobs now, which equate to full-time. She really, again, is remorseful for this incident, and based on speaking with her, I do not believe that this will ever happen again, Your Honor. She is able, well, she has saved up money to be able to pay fines and costs and the restitution in this matter today. And we would just ask for a brief period of probation to afford her the opportunity of HIDA.
Thank you, Mr. Dick. Ms. Campbell, you also have the ability to make a statement to me if you wish. Is there anything that you want to tell me?
I do apologize for the actions I did take. I know the things I took, I did without permission, and I knew it was wrong at the time. And I thought at the time it was the only way to provide food for my siblings. As my lawyer did mention, I was in a sheltered childhood. And I didn't know that there were other options out there. But now I do. So.
Tell me about where you're working.
I live in Atlanta, Michigan, and I am working at a bar. It's called Chatter's Bullpen. I do work there 3 days out of the week, and then the other 2 to 3 days, I work. I have my own cleaning company, so I clean an Airbnb and then other houses on the side.
Well, good for you. What's your family life like now?
I don't talk to my family anymore. They shunned me out of their life. It's just me and my boyfriend now.
That seems to be causing you some distress. Are you talking with anybody about that?
I have one friend I talk to, and then I thought about going to some therapy for it.
I would encourage you to do that. I'm not here to play social worker or therapist myself, but it seems to me that that is a big area in your life that needs to be dealt with. So I'll leave that to you. You seem like you have a good head on your shoulders and are a responsible young lady. But I don't want you to continue to go through life with a big hole in your heart. That may cause you to get yourself into circumstances that aren't good in the future. So let's deal with it now as opposed to pushing it off. All right. All right. I am going to put you on probation for a short period of time. 90 days, I think, would be sufficient. I am going to grant Holmes Youthful Trainee Act status, which means if you successfully complete the probation, this will be dismissed and will not be on your record. There is going to be, excuse me, restitution to Walmart in the amount of $281.94. There's a mandatory $75 crime victim fee and a $50 justice assessment. I'm going to reduce the court costs to $100, fine to $50, and a local charge of $15. Let me add that up for you. That's $290 in fines and costs plus the $281.94. It's a total of $571.94, which would need to be paid in full prior to the 90 days. You can work with the probation department on that. You may perform community service in lieu of some of those fines and costs at the discretion of the probation department. I am going to require you to enroll and successfully complete the economic crime class, and you can certainly show your completion certificate, if you've already done that, to the probation department, and that would satisfy that requirement. It sounds to me like you've got a somewhat flexible schedule. Would that be accurate?
Yes.
All right. I am going to ask that you, or I am going to order that you perform 8 hours of community service work within the next 30 days. And I do that for a couple of different reasons. One is I want you to have some time to think about what you did, and that you took something from the community. This is a way of giving back to the community. But I've found that people who do a service for others end up feeling better about themselves. And I think you need a reason to believe that you're a productive member of this society. And so giving back to somebody that's less fortunate than you would be one way of showing that. And you can feel good about doing that as a result. So the community benefits, but you also benefit. So I'm going to ask that you do that, and you can work with your probation officer as to where that's done. Typically, that's at nonprofits or public service agencies, and you may be able to find some of those over in the Atlanta area. If not, your probation officer will have some of them here in the Gaylord area. Any questions that you have, ma'am?
Not at this time.
All right, I'm going to give you the number of the probation department so that you can call them probably starting tomorrow to get started on your probation terms and know what to do. That number is 989-731-0215. All right, that'll be the order of the court. Thank you.
Thank you, Your Honor.
Next case is State of Michigan versus Kevin Chunko, file 25-43420-SM, set for a status conference.
James Dick on behalf of Mr. Chunko. Your Honor, I've still not been in contact with Mr. Chunko. He was originally at a rehab facility in Traverse City, and we had given him an opportunity to appear after his release. And since then, I have not been in contact with him.
All right. Looks like we had an original arraignment date of June 30th. I was in a hearing on July 23rd, at which I was informed that Mr. Chunko was in rehab in Traverse City. He was to be discharged on 8/6, so we adjourned the matter to 8/14. At the 8/14 hearing, he failed to appear. We issued an order to show cause because Mr. Dick had not had any contact with him. And we set today's date, and he has failed to appear again. So we're going to issue a bench warrant. State of Michigan versus Alexis McEwen, file 25-43574-SM.
James Dick on behalf. Oh, sorry. Ms. McEwen, who is appearing via Zoom, Your Honor.
All right. Do we have a resolution of this matter, Mr. Dick?
Yes, Your Honor. Ms. McEwen is going to plead to the drunk and disorderly, and it was my understanding that the prosecution would be agreeable to Haida, as she's had no prior incidents. And she was 25 at the time of the incident.
Mr. Portier?
That's accurate, Your Honor, as to the plea, and we do not have an objection to the court sentencing to Haida.
All right. Ms. McEwen, you've heard what the lawyers have said. Is that what you want to do?
Yes, sir. Or yes, Your Honor.
All right. You may have heard me discuss HIDA, or also known as the Homes Youthful Trainee Act, with the previous person that was before the court. That is a program that allows you to successfully complete it and then have the case dismissed so that there's no criminal record that you have. However, if you fail to successfully complete the program, you would have a criminal record. Do you understand all of that?
Yes, Your Honor.
All right. And is that what you want to do?
Yes, please.
All right. In order to take that offer, you would be required to give up your right to have a trial, and you would have to admit what you did. Your trial rights include the right to have a trial before a judge or a jury, the right to have your attorney, Mr. Dick, continue to represent you at that trial, the right to see, hear, and question all the witnesses at trial, the right to present your own witnesses and evidence and get an order from the court called a subpoena to require those witnesses to appear and testify. You could also testify, or you could remain silent. And if you chose to remain silent, that silence could not be used against you. You'd also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error at that trial. However, if you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand all of those rights?
Yes, Your Honor.
Do you have any question about any of those rights?
No, Your Honor.
Knowing all of those rights, do you still wish to enter your plea today?
I do.
All right, I'm going to ask you to raise your hand so I can swear you in. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, you can put your hand down, please. Has anybody promised you anything other than this plea agreement to get you to plead today?
No,
Has anybody threatened you in any way to get you to plead today?
no.
Are you doing this of your own free choice and free will?
Yes, Your Honor.
All right. The charge against you reads as follows. It says that on or about January 23rd, 2025, in Otsego Lake Township of Otsego County, that you did commit the offense of disorderly person drunk, in that you were a disorderly person by being intoxicated in a public place, that is the keg bar, and you were endangering directly the safety of another person or a property, or acted in a manner that caused a public disturbance. Is all that true?
Yes, it is true.
All right. What did you do at the keg bar that, well, let me ask it this way. What did you have to drink either at or before you got to the keg bar?
At the keg bar, there was liquor served.
All right. How much did you consume?
Few shots and at least 2 beers.
Did that make you intoxicated?
I was intoxicated, yes.
All right. What happened at the bar that caused you to come to the attention of the police?
A sensitive situation arose, and instead of handling it correctly, I was intoxicated and I became emotional, and I handled the situation in a disorderly fashion.
Tell me what it is that you did that was disorderly.
It was very loud. I caused a scene, and I definitely did not handle myself in a conductable manner whatsoever.
All right. So you disturbed the peace of the people around you at the bar?
Yes.
Is that a fair way to say it? And the people at the bar that were the owners or the operators of the bar ended up calling the police and they had to escort you out? Would that
No.
be fair?
There was no police that I
All right.
never encountered police that night.
All right. So but what action did the people at the bar take in response to your actions?
There was an argument that was had between me and one of the waitresses. I left up on my own accord.
Okay. All right. Do either counsel have any additional factual basis questions?
No, Your Honor.
Thank you.
Do either counsel know of any other promises, threats, or inducements not stated on the record?
I'm unaware of any, Your Honor.
Fair enough.
Do both counsel believe that I've complied with the court rule as to plea taking?
You have, Your Honor.
Yes, Your Honor.
All right. I will accept the plea. I do believe that she's given me a proper factual basis indicating that she was a disorderly person and was intoxicated at the keg bar and acted in a manner that caused a public disturbance by talking loudly, arguing, and causing inappropriate action, in her words, at the bar because she was intoxicated. So I will accept that. I believe she's given that plea knowingly, intelligently, and voluntarily based on the answer to my questions that I asked. Mr. Fortier, is there any victim that needs to be heard at this matter?
No, Your Honor.
All right. Mr. Dick, do you wish to proceed directly to sentencing?
Yes, Your Honor, if the court would.
All right. Ms. McCune, do you have any objection to proceeding directly to sentencing?
No, sir. No, Your Honor.
All right. I'm going to ask, just so that you know, Ms. McCune, I'm going to ask each of the lawyers for their thoughts as to what the sentence should be. And then I'm going to also ask you for your thoughts at the end so that you have an opportunity to hear what they say. So Mr. Fortier, your thoughts.
Your Honor, she's obviously pretty young, doesn't have a criminal history. We have no objection to the court ordering HIDA status to keep her record clean if she successfully completes a probationary term. As far as the length of probation, I would leave that up to the court. I would just ask that maybe having a assessment completed and then engaging in any recommended treatment might be beneficial, just so that she's aware of the dangers that alcohol can play in your life. I think other than that, I wouldn't ask for anything specific and would just leave any other additional terms up to the court.
All right. Thank you. Mr. Dick?
Yes, Your Honor. Currently, Ms. McCune is 26 years old. She was 25 at the time of the incident. As Mr. Fortier mentioned, she does not have any criminal record. The only thing she's ever been in trouble for was one speeding ticket. And aside from that, she's not somebody who regularly goes to bars, and she does work full-time in a newer career. She's a stylist and cosmetologist. This particular incident was, it's my understanding that it's a one-off, and some things that were perhaps unexpected or unwanted happened this evening of this incident, and that ultimately led to this outburst and reaction that would have otherwise happened in a different manner had she not been drinking. So we would just ask that the court, of course, extend HIDA to Ms. McEwen and assess her a brief term of probation.
All right. Thank you, Mr. Dick. Ms. McCune, you also have the right to address me, and this would be your opportunity to do so. Go ahead.
So just do you want me to tell you what happened? Is that what you're asking me?
You can tell me anything that you think that you want me to know at this time, whether that's explaining what you did or asking me to do something specific or not do something specific for a sentence. It's entirely up to you.
So basically just that night, I don't really go out. I don't go to bars. I don't go drinking. My friend had a birthday that day, so I decided to go out with them. I chose the wrong people to go out with after having seen the way they had conducted themselves in public before. But I made the decision, and that was my choice. I do acknowledge that. And then there was a situation that happened where obviously there are different statements and other people saying different things, but I had a situation where I was touched in a way that I did not approve of, and I reacted very loudly and emotionally, and I should not have reacted that way, but it was a moment that I wasn't sure what to do. I wasn't sure how to handle myself, and it was a shock. So I definitely am sorry for the way I reacted and for, having been under the influence when it happened, and I could have conducted myself differently. But I do take accountability for the fact that I was drinking and whatnot.
All right. Thank you very much for that. I know that talking about that is difficult for you, and I understand the emotion there, and I believe that you're handling things appropriately now, and I'm going to take that into account.
Thank you.
Alcohol and public places and difficult circumstances tend to lead to bad decisions. I think that you're recognizing that now. So I am not by any means penalizing you for reacting to a inappropriate contact. That is not what we're doing here.
Understood.
but I think you do recognize that your response to that could have been better and probably would have been better without the alcohol. So that's kind of where we're at this point. So I want to be very clear that I'm not in any way making what the fact that you reacted a problem. It is not. But even when bad things happen to us, there are still ways of dealing with it that should be done and are expected to be done. So that's all we're dealing with here, just that little difference. It appears to me that you have conducted yourself appropriately to this point in your life. So I am going to treat you as if this was a mistake and not an ongoing problem. I do believe that HIDA, the Homes Youthful Training Act, is appropriate. This is exactly what the situation that it was designed for, where somebody made a one-time mistake and they haven't made those problems become a problem in the past, and they probably will not do so in the future. So I'm happy to give you that opportunity to show me that you deserve that benefit. I am going to put you on Homes Youthful Training Act status for 90 days. There's a mandatory crime victim fee of $75, a justice assessment of $50. Court costs will be reduced to $100, it'll be a $50 fine, and a local charge of $15. That's $290.
Sorry, one more time.
$290. You can pay that over the course of probation, and you can work with the probation department on how to do that.
Okay.
You may also perform community service in lieu of some of those fines and costs. I think you may have heard me talk to some of the other people that we've had today about community service work. I like to use that as a way for you to give back to the community. I think it helps the community, obviously, by you doing that, but I think it also helps you feel good about yourself, saying, hey, I made up for my mistake and here's how I did it. And also by giving back to others, you feel good about yourself. And I think that that's important for you to have that feeling again, to know that you kind of paid your dues and you're done with it, and you can feel like you're a good member of society again. So I'm going to put down 8 hours of community service work, and you can work with your probation officer as to where you do that at, but typically it'd be a public service agency or a nonprofit organization here in town, and do that in the next 30 days.
I actually live in Farmington Hills. Is there any way I could?
You absolutely can do it down there. That's not a problem. You just have to get permission ahead of time from our probation officer up here. So if you have something in mind, you could suggest those things. But typically, if it is a nonprofit organization or a public service agency, the examples I typically give would be like the United Way, animal shelter, a food bank, any of those kinds of things that give back to the community. You'd be able to do that and just get the approval of the probation department ahead of time.
Okay, and I'm sorry, to do this community service, is there like someone that I contact for that?
Yep, I'm going to give you the number for that. That would be our probation officer here that will monitor how you're doing on your Homes Youthful Training Act status. I believe that the suggestion by the prosecutor was a good one, that you enroll in and successfully complete a treatment or educational program for substance abuse. There are organizations down in Farmington Hills, I'm sure, that do alcohol assessments. Typically, if you called one of the local district courts and asked who they use, you may be able to find it just in the by Googling substance abuse assessments, and then go there. It's usually a half-hour, 45-minute talk with somebody, and obviously there's a cost for that. And then they make a recommendation about what, if any, alcohol treatment you may need. You may not need any, but I want you to at least have an assessment done to say, okay, is this becoming a problem, or is it a problem, just so that you know and can make good informed decisions in the past, or excuse me, in the future, because you made a poor decision in the past as a result of that. So I'm not trying to punish you. Basically, I'm trying to make sure that you have all the information that you need to make good decisions in the future. So a substance abuse assessment and follow any recommendations. Because this was an alcohol offense, I'm going to say while you're on this Holmes Youthful Trainee Act status, you may not consume or possess alcohol. You may not go into a business where alcohol is served by the glass. That means no bars, even if they happen to serve food. You can go into a restaurant that happens to serve alcohol, but you simply can't go into the bar portion of it. And obviously you may not order alcohol with your meal for that. There will be a possibility of alcohol testing at the discretion of the probation department. So they could ask you to take a test. They could say, we don't care, but that's entirely up to them. I simply want you to know that we could test you at any time. So that gives you an incentive to not be using alcohol at this time. Any questions do you have about the court's order?
How do I get in contact with the probation officer is really my only question.
Yep, thank you for reminding me of that. The phone number to call probation here in Gaylord is 989-731-0215.
0215. Okay, thank you.
All right. Mr. Dick, any questions that you have?
No, Your Honor. Thank you very much.
All right, that's all for today. Good luck to you, ma'am.
Thank you. Have a good one.
Next case is the state of Michigan versus Robert Trudell, file 25-43796-SD, set for a status conference.
Yes. James Dick on behalf of Mr. Trudell. Mr. Trudell is on Zoom, Your Honor, and we do have a resolution to this matter today.
All right, I do see Mr. Trudell, and what is that resolution, Mr. Dick?
Mr. Trudell will be pleading to the amended count of operating while intoxicated in exchange for a dismissal of the original charge and the second offense notice. That's my understanding of it. Mr. Fortier?
That's accurate.
Thank you.
All right, Mr. Trudell, you've heard what the lawyers have said. Is that what you want to do?
Yes, sir.
All right, the reduced charge of operating while intoxicated has a maximum penalty of 93 days and or a $500 fine. There would also be costs of prosecution and community service work, but it would be a substantial reduction from the high blood alcohol level charge, which has a much higher fines and costs and community service work and all that other stuff. Plus the second offense notice would have which is going to be dismissed, would have had a mandatory minimum amount of jail time. That doesn't mean that there won't be any jail time possible, but it just means that it won't be a mandatory minimum. Do you understand all of that?
Yes, Your Honor.
All right. And is that what you want to do?
Yes, Your Honor.
In order to take advantage of that offer, then you'd have to give up your right to have a trial. So there are certain trial rights that includes. At a trial, you'd have the right to see, hear, and question all the witnesses against you. You could have a trial in front of a judge or in front of a jury. Your attorney, Mr. Dick, could continue to represent you at that trial. You'd have the right to present witnesses and evidence on your own behalf and get an order from the court called a subpoena to require witnesses to appear and testify. You could testify at trial, or you could remain silent. And if you chose to remain silent, that silence could not be used against you. At a trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt. And you'd have the right to have that burden of proof remain with the prosecutor at all times. Finally, at a trial, you'd have the right to appeal automatically any error at that trial. However, if you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand all of those rights?
Yes, Your Honor.
Do you have any questions about any of those rights?
No.
Knowing all of that, do you still wish to enter your plea today?
Yes.
All right, raise your right hand so I can swear you in to take some testimony from you. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right, you can lower your hand now. Has anybody promised you anything other than this plea agreement to get you to plead today?
No.
Has anybody threatened you in any way to get you to plead today?
No.
Are you doing this of your own free choice and free will?
Yes, I am.
The amended charge of operating while intoxicated would read as follows. It would say that on or about May 10th of 2025 in the city of Gaylord and Otsego County, that you did operate a vehicle upon a highway, that is the Idlewild Village Parkway, while having an unlawful blood alcohol level of above 0.08 grams per 210 liters of breath, or while being intoxicated. Is that true?
Yes.
Can you tell me what vehicle you were operating at that date and time?
2002 Dodge Durango.
And how much did you have to drink prior to operating?
It was a bit. I mean, I was drinking the night before and then slept some throughout the night and then had a little in the morning before I went to get tire work done.
When you say a little in the morning, what are you talking about?
I think I had like maybe a half a beer before I left the house.
What time did you leave the house?
Around 9:30
How
a.m.
much did you have? How much did you have to drink the night before?
I'm not sure. It was definitely more than a six pack. I don't know how much though.
All right. Did you take a test after you came into contact with the police for your breath or blood alcohol?
Yes.
Do you remember the results of that test?
Yeah.
What was that?
Around 0.29.
Yeah, you had more than a six pack the night before. Do you have any reason to contest the accuracy of that test? Mr. Trudell, do you have any reason to contest the accuracy of the test?
No.
All right. Do either of the attorneys have any additional factual basis questions?
No, Your Honor.
No, Your Honor, thank you.
Do either attorney know of any other promises, threats, or inducements not stated on the record?
No, Your Honor.
None, Your Honor.
Do the attorneys believe that I've complied with the court rule as to plea taking?
You have, Your Honor.
Yes, Your Honor.
All right. I do find that Mr. Trudell has given me a proper factual basis. He's admitted to operating a vehicle in the parking lot of the Idlewild Village Parkway while having an unlawful blood alcohol level on or about May the 10th of 2025 in Otsego County. And he's given me a reason to believe that he made that plea knowingly, intelligently, and voluntarily. So I will accept the plea. Mr. Dick, has there been a substance abuse assessment done yet?
No, Your Honor, there has not. There's going to be one done as soon as possible, and we'll get it back to the court. So we would just ask for a brief adjournment to be able to sentence him.
All right. Are we still in October the 2nd?
Yep.
All right. The next time I have available for that would be October the 2nd. That's a Thursday. We'll do the morning docket.
Yep.
We'll do a morning docket. So at 9 a.m. So Mr. Trudell, you'd be able to appear via Zoom. Again, you do the same thing that you did today. You're going to need to have a substance abuse assessment done so that I can review that prior to informing you what your sentence is going to be. Because we have to take an adjournment to do that, I'm required to tell you that anything that you do between now and then could have and will have a significant impact on what the sentence is, up to and including, if it's significant enough bad behavior, I could not allow or not accept the plea that you've just given to me. I don't intend to do that, but I reserve the right to do that depending on what your behavior is. So be very careful to be on your best behavior between now and then. All right, we will adjourn until October 2nd at 9 a.m. And then I'll see you then for sentencing and we'll go forward. Thank you, sir.
Thank you.
State of Michigan versus Kerrigan Thompson. That's file 25-43866-SD set for a status conference.
James Dick on behalf of Ms. Thompson, who is appearing via Zoom, Your Honor.
All right, I do see Ms. Thompson is with us. Do we have a resolution of this matter, Mr. Dick?
Yes, Your Honor. Ms. Thompson will be pleading guilty to the charge of minor with any blood alcohol content while operating.
So straight up to count one.
Yes, Your Honor.
Mr. Fortier, is that an accurate statement of the agreement?
It is, Judge.
All right, Ms. Thompson, you've heard what the lawyers have said. Is that what you want to do? I'm
Yes,
sorry, I
sir.
didn't hear you, ma'am. All right,
Yes,
thank
sir.
you. In order to do that, you would have to give up your right to have a trial and all of the trial rights that go along with that. So let me explain those rights to you. If you give up these rights, and you can have them if you wish, but if you give up these rights, there won't be any trial. There won't be you won't be doing a trial in front of a judge or a jury. You wouldn't have the right to have your, you'd be giving up the right to have your attorney represent you at that trial. You'd be giving up your right to see, hear, and question all the witnesses against you, the right to present your own evidence and your own witnesses, and to have an order from the court requiring those witnesses to appear and testify. You'd be giving up your right to testify yourself or to remain silent. And if you chose to remain silent, that silence could not be used against you. You'd also be giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt, because you'd be admitting it. And that burden of proof at trial would remain with the prosecutor at all times. Finally, you'd be giving up your right to have an automatic appeal of any error at trial. But if you enter a plea, you'd be limited to asking the court for permission to appeal. Do you understand all the rights that you'd be giving up? I'm sorry, wasn't able to hear you.
Your Honor.
All right, thank you. Knowing all of that, do you still wish to enter your plea today?
Yes, Your Honor.
All right. The charge against you reads as follows. It says that on or about July 28th of 2025 in Otsego County, that you did, being a person less than age 21, operate a vehicle upon a highway, that being Old 27, while having a bodily alcohol content of 0.02 grams or more, but less than 0.08 grams per 210 liters of breath. Is that true?
It was June 28th, but yes, sir.
I'm sorry if I misspoke. Yes, it does say June 28th. All right. What vehicle were you using at that time?
Using a Toyota RAV4 2023 from a dealership. It was a loaner car.
All right. And were you driving that vehicle on Old 27 at that time?
Your Honor.
How much you had to drink prior to that?
I had 2 long drinks in Torch Lake.
All right. And 2 long drinks, were those alcoholic beverages?
Yes, sir.
And at the time you were under the age where you should not be drinking, is that correct? And you knew that at the time that you consumed those beverages?
Yes, Your Honor.
All right. Any other factual basis questions by either counsel?
I think maybe just about the actual BAC.
All right, thank you. I appreciate that. Was there a test that was taken afterwards, Ms. Thompson?
Your Honor.
Do you remember the results of that test?
Yes, sir. It was a 0.07.
All right. Now, any other additional questions, counsel?
No, Your Honor.
None, Your Honor.
Ms. Thompson, you're not in any way trying to say that those tests that test was inaccurate in any way?
It was accurate.
All right, thank you. Either counsel aware of any other promises, threats, or inducements that are not stated on the record?
No, Your Honor, and the court has complied with court rule regarding the taking of pleas.
Mr. Dick?
Likewise to what Mr. Fortier said, Your Honor.
All right, thank you. I will accept the plea given by Ms. Thompson. I do find it to be knowingly, intelligently, and voluntarily given. She's indicated that she was a minor operating on Old 27, a particular vehicle within Otsego County with a blood alcohol level that registered between 0.02 and 0.08 grams. So she does qualify as violating the statute because she drank underage and then operated the vehicle. I believe we'll need a substance abuse assessment with that. Has one been done, Mr. Dick?
One is pending, Your Honor. Catholic Human Services has to reach back out to Ms. Thompson to schedule her appointment to complete it.
All right. Ms. Thompson, I'm required on drinking and driving related offenses to review a substance abuse assessment and recommendations as to what, if any, treatment you may need as a result of that. And so we're going to adjourn to accomplish that. In the meantime, I'm also required to tell you that anything that you do between now and then could be considered by me at the time of sentencing. And if the behavior is bad enough, I could say I'm not going to accept your plea. I don't intend to do that. I don't think it probably even it would be necessary in this particular case. However, I'm required to tell you that just so that you know that you need to be on your best behavior. Any questions about that?
And I did want to let you know I do have an assessment scheduled for the 11th.
Great, I appreciate that. So take care of that. I believe the next date that I have available for this kind of matter would be October the 2nd. You still got time then?
Yep.
All right, so we'll schedule this for October the 7th. Excuse me, October the 2nd at 9 a.m. And you'll be able to call in just as you did today over Zoom and take care of that then. Please be in contact with your attorney in the meantime. If there's any questions that you have, he'll be able to answer that for you. And if you don't get a notice in the mail in the next few days from the court, please contact your attorney so make sure that nothing has changed. Any questions that you have, ma'am?
No, Your Honor. Thank you so much. I appreciate it.
Yep, have a good day.
Thank you.
Next matter is the state of Michigan versus Virginia Totten. It's file 25-43877-SM.
James Dick on behalf of Miss Totten, and she is appearing via Zoom. Your Honor, I do want to mention to the court, I've not been able to reach Miss Totten, and because she is here, I'd like to provide her with my phone number so she can call me directly and I can get her contact information.
Go right ahead.
Ms. Totten, please tell me when you're ready to take down my phone number.
All right, I'm ready.
586-944-1651, and that's my direct line.
Okay.
So today, Your Honor, I know we are scheduled for a jury status conference, and I would ask if the court would give us a brief adjournment so that I can speak with Ms. Totten about her case.
Certainly, I think that's absolutely necessary. Ms. Totten, the court likewise has had mail that we tried to send you returned as no forwarding address. What or where would you like to receive notice of the next court proceedings?
The address is 5135 Chris Road.
That's Gaylord, right?
Yeah.
All right, I will make a note of that. October 2nd. Yep. The next date that I have available for proceeding like this will be October the 2nd. At 9 a.m. So you'll be able to call in via Zoom just like you did today. Please make sure that you contact your attorney and discuss all those things with him. Any questions that you have, any legal issues that come up, because I would like to resolve the matter, if at all possible, on the date of October the 2nd. Any questions that you have, ma'am?
No, not right now.
All right, make sure you get a hold of your attorney. We'll send out a notice to that new address.
All right, thank you.
Thank you.
Thank you, Your Honor. State of Michigan versus Anthony Wilkerson, file 19-37970-SM.
Larry Brown on behalf of Mr. Wilkerson.
Good morning, Mr. Brown. Do we have Mr. Wilkerson with us?
Your Honor, I do not see that name.
Mr. Brown, have you had any contact with Mr. Wilkerson?
I have not, Your Honor. I don't have any phone number on file for him. The last time I spoke to him was at the arraignment that I did for him back on June 18th. I believe this is a fines and cost matter.
It is, well, it is that. Let me check to see if it's also a failure to appear.
It is, Your Honor. It was back on August 14th.
Yep, so you're right, there was an arraignment on June 18th. We then had a hearing on August 14th. He failed to appear. We did an order to show cause because he's not kept in contact with you and he's obviously not here again today. We'll issue a bench warrant for his failure to appear today. State of Michigan versus Destiny Twitchell, file 25-43751-SD.
Larry Brown on behalf of Ms. Twitchell.
All right, I do see Ms. Twitchell is with us. We adjourned from July 30th after a plea to drunk driving the first offense for 30 days for getting a substance abuse assessment. Has one been sent in, Mr. Brown?
I have not, Your Honor. I spoke with her yesterday. She did get the assessment done. I believe she was going to send it to me, but I have not received it.
Ms. Twitchell, what happened?
I sent it out. Actually, I will go look right now. I sent it I sent it probably around 8 o'clock this morning. I'm about to pull it up. Make sure I put the email in correctly.
I assume you did that electronically?
Yes. Yeah, it says, yeah, it was at 8:23 this morning.
And you sent that to Mr. Brown?
Yeah, it says attorney at larrybrownlaw.com.
That is my address. I did not receive that. I'm not sure what happened.
I can try to forward it again real quick.
Judge, considering I guess we have quite a few people left, and it's already 11:30, can we potentially adjourn it so that Mr. Brown can get the assessment and then also provide it to our office and the court so that I have time to actually review it?
I believe that would be appropriate. That bumps us out to October the 2nd at 9 a.m. is the next time that I have available. So Ms. Twitchell, please make sure that Mr. Brown gets that substance abuse assessment so that he can forward it to the prosecutor's office and to the court so that we can all review that. And then we'll have you back on October the 2nd at 9 a.m. also via Zoom to make sure that we get good information prior to the imposition of sentence.
Okay.
All right, that's all for today then. You'll get a notice in the mail. Keep in contact with your attorney, please.
Thank you.
Next matter is State of Michigan versus Cheryl Barrett, file 25-43776-SD, set for sentencing.
Larry Brown, on behalf of Ms. Barrett, I do see her here. She is going to need to unmute and start her video.
Mr. Brown, do you have a substance abuse assessment for this matter as well?
I do not, Your Honor. I have spoken with Ms. Barrett. There is no communication problem here. She did have an assessment done with a Dr. Wong, who I'm not sure who that is. He was apparently supposed to fax it over to me. I have not received that yet.
Oh, there you are. Okay, I'm here. So sorry.
All right, Ms. Barrett, your attorney was just informing me that we do not have a copy of the substance abuse assessment yet. Do you know where it is?
No, I do not, Your Honor. I can get in touch with him on Monday and request it again.
By
For some
him,
reason-
Your Honor, I believe she means the doctor that did the assessment.
All right, is there some reason you can't get a hold of him immediately?
Pardon me, I'm sorry.
Is there some reason that you can't get a hold of him before Monday?
No, I could try to reach out to him even tomorrow. That would be fine.
All right, I just don't know how long it's going to take him to get here. Although we are going to have a bit of time because the next time that I have available is October the 2nd.
Okay,
So we're going to adjourn to October the 2nd at 9 a.m.
okay,
for sentencing. Please get a hold of that substance abuse assessor immediately and get the information to your attorney so that he can forward it to the court and the prosecutor so that everybody can be ready at that next court date. And obviously, because there's going to be an adjournment, you need to understand that anything that you do between now and then could have an impact on your sentence. So be on your best behavior. All right, that's all for today then. Thank you.
Thank you, Judge.
All right, the next matter is State of Michigan versus Cody Frost, file 25-43634-ST. Is Mr. Frost with us today?
Yes, sir. The host has asked you to start your video. Okay. Hi, sir.
Good morning.
Good morning, sir.
All right, Mr. Frost, this is a bench warrant arraignment. You have an attorney, Mr. Frost?
I do not.
All right, the bench warrant was sent out because you failed to appear for a show cause on July the 30th of 2025 on an underlying charge of license suspended, revoked, or denied. Bond was set at $500 cash or surety. What happened that you failed to appear on July the 30th?
Your Honor, I was in a transition of moving and I was working out of state at the time. And it was just a poor communication all the way around. I had found out about this bench warrant because I knew I had court coming up and I had called the courts to find out when that date was, and I was I was too late, and so they let me contact the clerk and set this hearing up without turning myself in, if that makes sense.
All right, well, you were arraigned back in May, and then we had a hearing in June, and I was told that you were at work camp and were not available. So we set it for July 18th and you didn't show up for that. So we set it for a bench warrant on July 30th and you didn't show up for that. So it's not just a oops, it looks like it's getting to be a have it. So if it's going to continue, you're going to find yourself in the jail as opposed to out of the jail. You understand what I'm saying?
I do, sir. I'm very sorry.
All right. I'll give you the benefit of the doubt, but can't happen again.
Yes, sir.
Are you going to want an attorney for this matter, the driving with license suspended?
No, sir. I was in contact with the prosecutor, and I'm in the process of getting my license back. And so he said as long as that happens, he'll work with me.
How long is that going to take?
The state of Michigan sent me some paperwork to have filled out by my doctor, and I have done that. And so I'm just waiting for the response of that.
About the most time that I can give you is into November, which is 45 or 60 days from now.
Okay.
So we'll do that. What time do we have near the end of November?
End of November?
Yeah.
The 30th, or sorry, the 20th would be our last day in November.
Because of the Thanksgiving holidays, November the 20th is as late into November as I can go. So it's not quite 60 days, but it's pretty close to it. Well, actually, it would be a hair over 60 days because this is the beginning of September. So that gives you as much time as I can give you. So we're going to need to resolve this one way or the other on November the 20th.
Okay.
All right. So if this gets close to that date, you're going to need to be in contact with the prosecutor as long as you're going to be representing yourself to try to figure out, have I done everything I need to do? And if not, where do we go from here? And usually that means a phone call to his office to discuss it with him. Mr. Fortier, you still doing pre-trials on Wednesdays?
We are, Judge, and actually what I was going to ask is if we're going to move his court date to November 20th, if we can go ahead and set it for a pre-trial right before that, maybe even on November the 12th or the 19th, so the day before. Doesn't really matter to me, just so that we can at least make contact.
I think that's a great idea. We'll set this for a pre-trial conference on the 19th. Mr. Frost, that means that you're going to need to call into the prosecutor's office on the 19th. Talk with Mr. Fortier or whoever is available on that date about the case to see what needs to be done, if anything, to resolve it. And then on the 20th, you'll talk with me and let me know what agreements you've reached, if any, and how the case is to be resolved on the 20th in court. That would be by the Zoom process that you did just like today. You have any questions about that?
No, sir. Thank you so much.
All right. Good luck to you getting working with the Secretary of State, and we'll
Thank
see you
you.
on the 20th.
Thank
All
you
right.
very much.
That's all for today.
Thank you.
Judge, real quick before you call the next case, I see that Nakoa Nelson is on here. He's represented by Mr. Dick. That case is actually set for the afternoon.
All right. Mr. Nelson, if you want to dial back in this afternoon, you have a question?
Yeah, what time? I thought it was at 10:45 and I thought I was late. What time is it?
1:45.
1:45.
1:45? Okay. Okay, I just wanted to say I'm in the middle of job searching right now and I have an interview at 2:30. I don't know. I know I'm not, you'll call me when you call me, but I was just wondering if we might be able to work something out to where I might be able to get called earlier.
I'll make a note, see if I can help you out this afternoon. So job interview at what time did you say?
It's at 2:30.
All right, I'll do my best to get you on as early as we possibly can. You can remind me of that this afternoon, all right? I'll see you then.
All right, thank you, Howard. Bye-bye.
Next matter is State of Michigan versus Cale Ashton, file 25-43871-SM, set for a status conference. I
Yes,
assume
Your
Mr.
Honor.
Ashton is with us. Mr. Ashton, do you have an attorney?
No, I do not.
So you're going to be representing yourself today?
Yes, Your Honor.
Have you had a pretrial conference with the prosecutor?
I actually called on August 27th a couple times and left some voicemails trying to reach out to Mr. Fortier, and I left a couple emails as well, and I didn't get anything back, so I haven't had the opportunity to speak with anyone.
Mr. Fortier, would that be of assistance?
Well, Judge, so I did receive his email. There was quite a bit of attachments listed there. I didn't get a chance to return his phone call simply because last week I was pretty much the only one here because Miss Brooker was out, so I didn't get a chance to speak with him. I would be more than happy to give him a call probably tomorrow, just so that we can discuss the matters and discuss what he had sent via email.
I think that would be appropriate for the parties to talk and see if there's a way to resolve the matter or how they might work things out. I believe the next court date available, however, is not until October the 2nd. So we'll move this out to October the 2nd at 9 a.m. For the parties to discuss negotiations. All right, Mr. Fortier, you're going to call Mr. Ashton, is that correct?
I am. I'll call him tomorrow.
All right, you have his number?
I do.
All right, so Mr. Ashton, expect that phone call. Please discuss anything that you believe would be pertinent with Mr. Fortier. You're not required to reach an agreement, but obviously it may be in your best interest to do so. That's entirely up to you. And if you are able to reach an agreement or you're not able to reach an agreement, we'll have a hearing on October the 2nd, and you can tell me what it is that you want to do at that time. All right? Thanks,
Absolutely.
sir.
Thank you.
That's all for today. Next matter is State of Michigan versus Dylan Martin, file 25-43675-ST. I do see Mr. Martin is with us. I have a note from the arraignment on June the 2nd that we were adjourning this for a number of months to see if Mr. Martin could get his license back. Have we succeeded, Mr. Martin? Looks like Mr. Martin is frozen. Can you hear me, Mr. Martin? Are you still with us, Mr. Martin?
Your Honor, if you'd like, oh, hold on, it looks like he's coming back in. Dylan, are you there?
I'm sorry about that. My microphone wasn't working. I had to go to my settings to unmute it. I'm sorry. Can you hear me?
Oh, yeah, we can hear you and I can see you now, so that's good.
Sorry
The
about
question
that.
was, the question was, what's the status of your license restoration?
So I called Florida because that's where my license was revoked from, and they basically told me you have to come down and serve the time in Florida to get your license back. And I told them I have 3 kids up here, and is there any other way like I could take a class or any? And they said no.
All right. Mr. Fortier, how do you want to proceed given that information?
Your Honor, I did speak to him on August 27th, and essentially we were just going to proceed with the charge as is and just recommend fines and costs.
All right, Mr. Martin, is that what you want to do?
Yes, Your Honor.
You realize that may have a and an impact on your ability to get your license back in the future?
Yes, Your Honor.
All right, knowing that, is that still what you want to do?
Yes, Your Honor.
All right. If you want to plead, you'd be giving up your right to have a trial and all the rights that you would have in that trial process. So the rights at trial would include the right to have a trial before a judge or a jury, the right to have an attorney represent you at that trial, the right to see, hear, and question all the witnesses against you, the right to present your own witnesses and evidence and get an order from the court requiring those witnesses to appear and testify. You'd be giving up your right to testify yourself, or your choice to remain silent. And if you chose to remain silent, that silence could not be used against you. You'd be giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof remain with the prosecutor at all times. Finally, if you don't have a trial, you'd be giving up your right to automatically appeal, because if you enter a plea, the only thing that you can do is ask the court for permission to appeal, and that might not be granted. Do you understand all those rights that you'd be giving up?
Yes, Your Honor.
Knowing all that, is it still your desire to enter this plea today?
Yes, it is.
All right, let me take some testimony from you. Would you raise your right hand, please? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, you can put your hand down. Has anybody promised you anything other than this plea agreement to get you to plead today?
No.
Has anybody threatened you in any way to get you to plead today?
No.
Are you doing this of your own free choice and free will?
Yes.
All right. The charge against you reads as follows. It says that on or about April the 20th of 2025 in Bagley Township of Otsego County, that you did operate a motor vehicle upon a highway, that is I-75, while your operator's license from the state of Florida was suspended or revoked. Is that true?
Yes.
Do you remember what vehicle you were operating at that time?
It was a 2014 Chrysler 200.
And why was your license suspended in Florida?
It was for a DUI.
All right. And you were operating that vehicle on I-75 in Bagley Township of Otsego County?
Yeah, I'm sorry, I'm not from that area. I was
Near
traveling
Gaylord?
Yeah.
Okay, so on I-75 near Gaylord, right?
Yeah.
Okay. All right. Mr. Fortier, any additional questions as to a factual basis?
No, Your Honor.
Do you believe I've complied with the court rule?
You have, Your Honor.
Are you aware of any other promises, threats, or inducements not stated on the record?
I am not, Your Honor.
All right. I do find that Mr. Martin has given me a proper factual basis. He's admitted to operating a vehicle on I-75 near Gaylord while his license from Florida was suspended, and he's told me he did that knowingly, intelligently, and voluntarily by saying that there was no promises, threats, or inducements otherwise. So I will accept that guilty plea. All right. Mr. Fortier, anything other than your offer to do fines and costs that you want to let me be aware of?
No, Your Honor. I think Mr. Martin did everything he could. So I don't think we should penalize him any more than just having him pay fines and costs, because he's going to have a hard time getting his license back. And it's just kind of where he's at.
Mr. Martin, is there anything else that you want me to be aware of before I impose fines and costs?
No, Your Honor.
All right, I will go along with that agreement. There's a mandatory $75 crime victim fee and a $50 justice assessment. I'm going to reduce court costs to $75 with a fine of $25 and a local charge of $15. That's $140. Can you pay that within 30 days?
Yes, Your Honor.
Let me give you a number where you can call the court to make sure that you make that payment. It's 989.
I'm sorry. I'm sorry. I'm sorry.
All right. Can you get something to write with?
Yeah, I got it right here.
The number is 989
989
731
731
0201. That's the court payment line. If you call there and tell them that what your name is, they'll be able to indicate what the payment is. So $140, pay that within 30 days, you'd be good to go.
Okay, thank you.
240.
I'm sorry, it's 240. I apologize. I
240. Okay. I'm sorry. Can
240,
you
yeah.
repeat?
$240. Call the payment line at 989-731-0201.
Okay, sounds good.
Thanks for catching that. Yeah. All right,
Okay.
that's all for today, sir. Good luck
All
to
right,
you.
thank you.
State of Michigan versus David Smith, file 25-43730-ST. We have Mr. Smith with us.
He's here. I'm asking him to unmute and start his video.
All right, I do see Mr. Smith is with us. Mr. Smith, do you have an attorney? Can't hear you, sir. You're on mute. You're still on mute.
There you go. Hold on.
There you go.
Okay, I'm sorry, sir. Not this time, Your Honor.
I gave you Mr. Gilo's number last time.
Yes,
Because you
I
asked.
think I might have copied it down wrong, and I've been going through a foreclosure, so I've been pretty preoccupied. I do apologize to your court for that. There's really no other excuse except for that's the reason why I have not done it.
Do you still want an attorney?
Yes, sir. I believe I need one.
You're going to have to make a little more effort this time than just saying you got preoccupied.
I understand, sir.
All right.
It's
The number for let me give you the number again for Mr. Gilo's office. It's area code 989 732 8030.
8030.
I'd ask you as soon as you're done here to make a call to his office. Tell him that you need to get qualified for a court-appointed attorney, and then his office will be able to appoint one for you. The next date that we have for a court date is October 2nd at 9 a.m.
Yes, sir.
If you don't have an attorney by then, we're gonna proceed. I'm just gonna assume that you're gonna represent yourself. So if you need an attorney, you need to get one. You understand?
Yes, sir. And I do apologize to the court again, sir. I'm sorry.
All right. I'm giving you the benefit of the doubt, but just make things happen. All right. That'll
Yes,
be
sir.
all for today.
Thank you. That it? You're done. Hold on. So
State of Michigan versus Michael Turner, file 25-43734-ST. Set for a status conference.
I'm here.
You see Mr. Turner is with us. All right, Mr. Attorney, do you have an attorney?
No, Your Honor. I was financially unable to afford one in the time that you gave me, so I'd like to ask the court to appoint me an attorney.
All right. I'm going to give you a number of the attorney that deals with court-appointed attorneys, and he'll ask you some questions to see if you qualify financially for a court-appointed counsel.
Okay.
So you're going to need to call his office and go through that process with him. I have approved that request if you qualify financially for that, and then he will tell you the attorney that's going to represent you if you qualify.
Okay.
So the number you need to call is 989-732-8030.
Okay. And is that Gilo?
Yep.
Gotcha.
He's the one who he will appoint the proper attorney to represent you if you qualify for court-appointed counsel. The next date that you'll need to be in court is October 2nd at 9 a.m. And if you if you contact Mr. Gilo and he does appoint an attorney for you, you'll need to give that notice to your attorney as well. So we'll send it out to you, and if we get contact from another attorney, we'll send it out to them, but you need to advise them when it's coming up. Any questions that you have?
No, Your Honor.
All right, that's all for today then. Thank you very much.
Thank you.
All right, looks like the last two things this morning are all the same person. State of Michigan versus Larry Patilla. It's file 21-39269-SM set for a bench warrant. Then we also have file 20-39111-SM also set for a bench warrant. Do we have Mr. Patilla with us?
There's no one else in the courtroom, Your Honor.
All right, looks like this is a failure to pay. In file 39269-SM, he owes $814 and a bond of $500 was applied 7/29 of 25. Then it looks like in file 39111, he owes $925 and a bond of $500 applied on 7/29. And the only other payment was back in September of 21. For failure to appear today, we'll issue bench warrants on both files. And that will be the end of the morning's docket. Thank you, Mr. Fortier.
Thank you.